7 FM. Telephone number to call is 0116 482206. If you want to text or WhatsApp, which is a lot easier, 0774 885 5055. Okay, so we've got the legal show. I'm Rafique Patel from Bond Adams Solicitors, and I've got my colleague here today from our property department, Ibrahim Kadri, who's a partner in our property department. Ibrahim, do you want to say hi to the viewers today?
Assalamu alaikum. Those of you who are tuning in whilst you're driving around during your Ramadan preparations or getting ready for iftari, or even if you are watching live on YouTube or on Facebook, Ramadan Mubarak from me. My name is Ibrahim Kadri, partner solicitor. Looking forward to discussing property-related topics with an overlap of litigation with Rafique Patel.
Okay, Ibrahim, thanks for coming along today. One of the big issues that's happening at the moment is a lot of sales and purchases of freehold property.
Yes.
And there's also leasehold property, which is a new concept that many people are buying because freehold property is becoming very expensive. However, what that's done is it's driven up demand. On social media, you see people buying auction properties very regularly, sometimes not carrying out a great deal of due diligence, fear of missing out, those type of things. And Ibrahim, I'd like to talk about some of the sadly issues that can arise from these type of property matters, as you regularly do get involved in conveyancing. So one of the issues that's been flagged up is someone's bought a property. They decided to go ahead without doing something called a local authority search. And they've now found that their neighbour has removed the boundary, and the neighbour's telling them that they can do whatever they want as it's their boundary. And what's the situation about boundaries? It's always a very difficult area.
Yeah, this is a great topic, and depending on what time you ask the question and who you ask the question to, you'll get different responses. When you're buying a normal freehold residential property, when you get in touch with the seller's solicitors, you need to request what's called the protocol information form, the property information form. Now, 9 times out of 10, the vendors do answer a question, which is, what side of the boundaries are you responsible for? The front, the back, the left, or the rear? Now, a lot of people don't know what they are responsible for. Therefore, they take a response not known or unknown. Now, you as the buyer, there's a concept called buyers beware, and that's very much true. So you as a buyer, you've got a duty to physically inspect the property, make some inquiries, also go and speak to neighbours if that makes sense. Through your solicitors, ask questions. Have your clients experienced any boundary disputes? Have there been any claims? How frequently or how regularly has your client had to maintain the boundary features? All this adds substance to what we are trying to establish. Going back to your point about the local search is very crucial. 9 times out of 10, when people buy properties and they do so with the aid of Islamic finance, normal mainstream finance, a local search is required. A local search is a very important document which details planning history, building regulations history, and more importantly, in what you come across, Rafique, litigation, is it also notifies the buyers if there's going to be a new road being built on an area.
So Ibrahim, thanks for that. But just on this question about a boundary dispute, what's the situation? The neighbour's saying that it's his boundary and he can do whatever he wants.
Well, that's wrong to an extent. I mean, you know, when you are faced with that kind of situation, then it's good to get a surveyor out, get the land registry out, and get the local authority out. And therefore, you're doing more of a fact-find exercise. When you look at the land registry title plan, usually you've got some T marks on the plan. It's hard to describe. Obviously, we haven't got a plan at the moment, but anything marked inwards usually is the owner's responsibility to maintain.
All right. Thanks, Ibrahim. So we've got quite a lot of queries that have come in, so I'm going to move you on. So just a reminder, everyone, we're on the legal show with Rafique Patel and Ibrahim Kadri. If you want to text or WhatsApp in, it's 0774 885 5055. So Ibrahim, another query that often arises, that someone says that they're doing some work in their garden, they want to build a bit of an outhouse, but there is a water trunk main in their garden. What they're saying is they've spoken to their solicitors who did the purchase, and the solicitor said, well, they did flag it up on something called a water search. What's that all mean?
Yeah, I mean, again, we touched on this briefly when we discussed the local search. So a water search is crucial. You need it before you complete on a property purchase, especially when you've got a lender on board, whether it's Islamic finance or high street finance. And a water search would flag up whether the water connections are adopted either by a local water board or if any of the manholes or the sewers have been relocated. Now, usually when there's development that's taken place, one often tends to remove certain connections and relocate them. Now, if that's not been declared and then you go and then build, you could not only be in breach of local regulations, you could be in breach of, let's say, for example, Severn Trent.
Ibrahim, so what this query is that they've seen a line which shows that there was a water trunk in the garden. Is it their client's fault, or what's the situation?
So if they've seen a water trunk, are you saying it's been built over?
Yeah, they want to build on it.
They want to build over it, right? So therefore, you would need to get the adequate permission from Severn Trent, from the local authorities, to ensure that one can access the water trunk in the future. Because if you're going to build over it and there's a problem, what if that water trunk is serving a number of properties, not only that individual property? Therefore, there would need some sort of relocation.
So clearly, doing good due diligence is absolutely critical.
It's absolutely critical now. Like you said, the lawyer flagged it up. The lawyer flagged it up when they were buying the property. Now, subsequently, they could now go and sell it. Someone's looking to buy it. Again, do the due diligence.
Okay. Ibrahim, we've got another matter that's come on. This is the legal show with Rafique Patel and Ibrahim Kadri. This week concentrating on property matters. We've got a situation where someone's bought a property, it's got a conservatory, and local authority has come along and said, I'm sorry, but it doesn't have planning permission and it doesn't have any building regulations. I'm afraid you're going to have to take it down. And what's the situation with that? The client's decided obviously to give the work to a lawyer, and that's what the local authority is saying. What happens next?
Right, so then you are buying this property, the local search has revealed, or your inquiries have revealed that there's a conservatory there from your physical inspection. You, as the buyer, through your solicitor, have to ask those questions. Why was planning permission not sought? This can affect any future refinance or any future salon. Now, the current owner, they've got two options. They can get retrospective planning permission and building regulations. Again, it could go either way. Or you as the buyer can insist on an indemnity policy. Now, you've got to understand, if the event took place with less than 10 years, then enforcement action from the local authority, I'm not saying it's impossible, but the chances are remote. Therefore, a building regulations policy would suffice.
Can I ask you this? It seems as if certain documents can be put in place.
Yes.
Insurance, for example, we all know that insurance might pay out, it might not pay out.
Yes.
But this person's saying that when they come to sell,
yes,
and obviously the buyer's going to ask for building regulations and planning permission,
yes.
Is that going to be an issue in terms of haggling on the price?
Yeah. If it's a cash buyer, then obviously you've got more room to negotiate, but you've got to understand most buyers do buy with the aid of lending. Now, they don't all buy with mainstream lenders. Some buy through adverse lenders, and therefore the lender's requirements might be as such that they want certain things being put right. So if you've got a extension or a conservatory that has not met building regs or does not have planning permission, then that can affect any future refinance or any future salon.
All right, that's great. Thanks for that. Just a reminder, it's the legal show, Rafique Patel, Bond Adams Solicitors, and Ibrahim Kadri as well from Bond Adams. And just a text and WhatsApp reminder for you, 0774 885 5055, and it's 87.7 FM. We're just talking with Ibrahim Kadri, partner, in terms of some of the conveyancing nightmares that sadly can happen when you don't do your due diligence. And we've spoken about conservatories not having planning permission, building control. We've talked about water trunk mains in your garden. And we've talked about boundary disputes. I want to talk about another one now that's quite common as well. Basically, someone's bought a house, they looked at it at the stage one,
Yes.
thought it was really nice, exactly what they wanted. They've bought it, and now they've gone in, and there's been all sorts of damage to the walls. Obviously, they knew there was a tenant in there that was leaving. There's damage to the walls, things have been ripped out, and it's going to cost about £10,000 to put right. What's the situation here then?
One thing I say to all my clients, and I'll use a term here called duress. Sadly, when you're dealing with conveyancing transactions, the lawyers are put under enormous duress, or the people buying or selling, because they've got to meet certain deadlines. Now, the time when you inspected the property, when you made your offer, it was quite some time back. Most conveyancing transactions, if you do them properly, they do take a bit of time. Let's say 6 to 8 weeks, maybe 10 weeks. What I would suggest is, please inspect the property before you do the physical legal exchange. Because like you said, if the property's been altered, if the kitchen's been ripped out, the bath's been ripped out, or the tenant's damaged the properties, this is a perfect opportunity for you to go back to the estate agent or to the vendor to say, look, hold on, this is not what I agreed to buy. I agreed to buy a property of a certain standard. This has now fallen below the standard. It's going to have an impact on my lending. It can have great impact whatsoever.
So let me ask you this. If in the documents, for example, it said curtains were included or a kitchen was included and it's been ripped out, are you saying that you can do something about it?
Yeah, of course you can. Of course you can. We've sent the protocol forms to the client. The client's physically seen the property. The vendor's ticked the boxes on the protocol form to say a kitchen's included, appliances are included, a bath's been included. Now, your client, as in our client, goes and is looking to buy the property, they're looking to exchange, and they realize, hold on, everything's been ripped out. All I'm buying is walls. At this stage, you've got a right to raise this with the estate agent. Physically, the legal exchange has not taken place.
Let me ask you this then. What if, for example, coat racks and hooks and shelving's been taken out and there's holes in the wall everywhere? Can anything be done about that, or is that just...
No, that's just cosmetic. Unless you agreed with the vendor that before you remove all the movable items, you will agree to plaster the walls or fill in the holes, then that's another story altogether. But anything that you do agree, make sure not only is it verbally agreed, it's agreed in party correspondence and it's in writing as well.
Okay. Thanks a lot, Ibrahim. I'm just going to recap for listeners where we are at the moment. So it's the Legal Show with Rafique Patel and Ibrahim Kadri, and we've been talking about the very common situation at the moment of buying and selling property. Obviously, prices are going up. There's some urgency that's generated, and we talked about some very serious problems that can arise, and Ibrahim spoke about a boundary dispute that's arisen, planning permission and no building regulations for a conservatory. We talked about not being able to build in your garden. We talked about the condition of the property being damaged when you've gone in. There's something else that is quite a frequent issue, is that, for example, you can go on the internet and get your legal process done for buying a property for £195. There's some solicitors who charge £1,500. There's some that charge £750. Why is there such a disparity if basically all lawyers are doing the same thing?
I think when you are dealing with platforms, online platforms, as you know, we live in a very sales-driven world. It's a very marketable world. Now, that headline price of 195 might be your headline price to lure the client in, the customer in, and by the time you end up completing, you're faced with a big bill of many, many add-ons that you weren't aware of. And a lot of law firms are very transparent. They are, we are governed by the SRA and CLC and the Law Society, and some of us are Lexel accredited as well. So we've got a duty to be transparent. So when we do quote and pitch for services and pitch for work, we've got to outline as to what service we're providing and how much we are charging. So we have a headline price, we have other elements like we're acting for lender or financial due diligence, and then there'll be something like the disbursements, posh way of saying expenses. This encompasses searches, land registry fees, etc. Now, these online platforms, when they say your conveyancing is from 195, that attracts the customer. And also, like when you're buying a service or you're performing a service, what you pay for is what you get. So certain firms charge a certain premium, and you do 9 times out of 10, you get that level of service.
But let me just ask the question. I appreciate that in terms of communication and speed of service, they're really good when we're buying a holiday or buying a lawnmower or whatever it is. But what's the difference in that kind of price? Surely there must be more you're getting for that.
Well, you're getting a personal touch, you're getting a legal service, you're getting a bespoke legal service. Now, you mentioned something at the start of the show, that housing market's crazy, loads of first-time buyers, high demand, low supply. We're dealing with a population of society that are first-time buyers. Now, the first-time buyers want a certain level of service. If you're an experienced campaigner, it's a different story altogether. But a first-time buyer who are buying their first property, they want to know what's happening with the property to avoid all the problems that you've discussed today, such as boundary disputes, such as flagging up certain issues. So therefore, when you are paying for a certain service at a certain level, you expect something in return. So these law firms that charge a premium, one would expect that they would deliver a nice level of service to ensure that the client's at peace and the client's aware of what they're buying.
All right, so thanks for that. Just a reminder, everyone, that we're on the legal show with Rafique Patel and Ibrahim Kadri. Text WhatsApp 0774 885 5055, and it's 87.7 FM. We're just going through the property market at the moment. Many of you buying and selling properties, obviously the prices are going up, and even agents are putting documents through your door asking whether you're interested in selling to kind of generate interest. But there is sadly quite a dark side to going through the conveyancing and not doing the due diligence on what you're actually buying. So we spoke with Ibrahim about a number of issues that arise. In fact, Ibrahim, I've just had a text in from someone listening saying that the voice is very low. Just a quick one for those doing the mic, but if we speak up a little bit as well.
Yes, so I think, Rafique, one thing that you've raised, which is really good, is the dark side of the property market. And this adds to, obviously, duress, pressure, and then mistakes happen, and sadly, clients suffer. So it's a bit of a horror story, but if we get it right from day one, we can avoid all these problems. So the key thing would be is never give in to pressure. Yes, stock is low. There's a lot of competition out there, but you as a buyer need to make sure that you are happy with what you're buying. So therefore, please inspect the property, get a RICS qualified surveyor to see the property as well before you even think about departing with your money.
So Ibrahim, I'm just going to run through some of the sad cases that we know about. One was somebody ends up with a boundary dispute. Ibrahim, you might need to have the mic a bit closer to you. One was a boundary dispute. One was sadly someone bought a property without planning permission for a conservatory. Someone wants to build in their garden, and there's water apparatus there. Someone bought a property, they viewed it initially, and when they went to move in, it was all damaged. I'm going to talk about a few other problems that can arise as well. So one of the things that happens is financial due diligence. What they're saying is that the lawyers are now starting to ask where the money came from for the purchase. Bank statements been given to show that the money's actually been sitting in the bank account, but they're going on further to ask, where did it actually first come from? What's that all about, and why the change?
Yes, there's a greater responsibility on the lawyers to carry out financial due diligence. We've had some horror stories whereby it's all fair and good, the buyer's informing the mortgage broker or the lender saying this is where we got the money from, but these lenders, just before they release funds, they do a further credit check, and if anything adverse has been picked up, sadly, the funds will not be released. And if you've exchanged on a property, then you are obliged to buy the property, or you can lose your deposit or face a legal claim. So as solicitors, as lawyers, we send out a source and proof of funds disclosure form. It's got a statement of truth on it. The client's got to disclose where they're getting the monies from. So if an uncle or aunt has given money, yes, we will approach them. We will ask them where they've got the money from. And obviously, what we know and what we establish has got to be consistent with what the lender's got as well. Sometimes clients tell a lender that there's only one party that's giving us a gift, and when we ask them the same question, there's 3 parties giving a gift. Now, a lot of people don't understand what a gift is. Some people...
Ibrahim, before we go on to gifts, though, why is it important that the lawyers are asking about where the money first came from?
Yeah, because they want to know, have the monies been obtained from legal sources? Is it from earnings?
What do you mean? Give us some examples of...
So, for example, you've got somebody that is buying a property. Now, if they've been saving up since the age of 16 and they've been saving up since 1996 and they've amassed 80 grand's worth of savings and they've had one job and they're on that steady income, you can see where their money's come from. There's a trail there. But all of a sudden, you go through their bank accounts and you see cash has been deposited, £6,000-7,000 at regular intervals, or various third parties have deposited money. You know, with your litigation type of work that you carry out, with this Proceeds of Crime Act, you can't be using money that's been gained from immoral means to fund a property. So this financial due diligence exercise, you're trying to sieve out where the money's come from. Does it match up with what the lender's aware of? And do you feel comfortable in signing that part of the file off? And also, it doesn't give any third party a rise to the property as well. Because if you've got somebody that's deposited money into a buyer's account, but they don't want the name in the property, are we then saying 3 years down the line, they gave X, Y, and Z some money, therefore they should have a right in the property?
That's a very interesting point, actually, because many families are now helping, usually the couple, trying to buy a property, and I'm going to come on to that in a moment, but I'm just going to recap with just 20 minutes to go. So it's the Legal Show with Rafique Patel and Ibrahim Kadri. Text, WhatsApp, it's 87.7 FM. Just remind you of the number 0774 885 5055. If you want to call in, 0116 482206. So we were speaking with Ibrahim about the property market and how sadly people have bought houses, number of issues, boundary disputes, lack of planning permission, properties being damaged when they go to buy, and we're talking about now we're on to gifts. Now, one of the things that's commonly happening now, because house prices are sadly what they are, many family members are helping what is normally the couple with some money. Now, that gives rise to a number of issues. We've seen, sadly, a number of breakdowns later on in terms of the gift or a loan or whatever it is. And what's the situation where so many family members want to give a gift to the couple? What kind of issues can arise?
I think you raised a key issue there, is that if it's a gift, it's a gift. You're not expecting the money back. But some people get confused with a gift and a loan. So it could be a loan, but they use a tag, the term gift. Now, as a law firm, our duty is to the lender if you're acting for the lender, and our duty is also to the people that we are representing. We don't represent the parties that are giving the gift. Therefore, for our clients' peace of mind and to avoid any future dispute, and for the sake of transparency, we would ask the gifted party to obtain their own independent legal advice.
What does that mean, Ibrahim? What does that mean?
That means that they've got a right to go and see a lawyer. So the lawyer makes them aware as to what they're doing with their money and the lawyer would confirm that they will have no right to that property going forward. And they will sign a form, they will sign a waiver, and some lenders are even asking for these documents as well, not only at the stage when the mortgage offer is issued, but also before the release of funds. Now, a lot of people that gift money, they get confused. They reckon they're going to have a stake in the property, but what they don't realize is if their name's not on the property, that property will not be theirs. However, they've got a financial interest in the property.
So can I give you an example then? So we've got a scenario where mum and dad are helping son and wife, or the other way around, with some money, and they've obviously got an expectation that they're going to be allowed to stay in the house.
Yes.
But suddenly, sadly, what happens is the couple say, it's time to leave, I'm afraid, because we own the house. What's that all about?
That basically, so the mum and dad, they agreed to give this money on the basis that it's non-returnable, but they would get to stay in the property. And if that's been declared to the lender will insist that the mum and dad sign occupiers' consent forms.
What does that mean?
And that means that the occupiers have got a right to stay in the property. However, if the lender repossesses the property, then the occupiers don't have a right to stay in the property. So that's from the lender's perspective. But going back to your point about the son and his wife kicking the parents out, that then becomes a personal dispute. Then you see the parents saying, hold on, I gave the money on the understanding that I'd be able to stay in the house. Now, if you have this situation or you smell this situation, then it's important that the parents say, you know what, we actually want our names on the property. Okay. And that would give them a better level of protection.
Where does that stand if they're borrowing money from a traditional lender? Will the lender allow their names to be on the property?
It depends how the mortgage offer has been issued. At the moment, we're hearing a number of terms which we weren't hearing maybe 3-4 years ago, which is joint borrowers, sole proprietor. We're hearing, this is not a lending show, so I don't want to get too technical about lending, but we're hearing different terms. But the key thing is that the mortgage, whatever's on the mortgage offer, whatever's on the special conditions, whether it's a gift or whether it's about occupiers, it's got to be consistent before you complete. Now, if any party is gifting money but the name's not on the property, always direct them to have independent legal advice. And the same thing applies with occupiers as well. If a parent is giving money to a child on the basis that they're going to stay in the property, that becomes a different type of transaction and is a question that you've got to ask your client and the gifted party. When they get the independent legal advice, their representative would also ask them that question as well.
Okay, so Ibrahim, that takes me on to another question regarding, sadly, the issue of divorce, but we'll come on to that in a minute. Just a reminder, we're on 87.7 FM, Ramadan FM, and this is a legal show with Rafique Patel and Ibrahim Kadri. If you'd like to text or WhatsApp in, it's 0774 885 5055. If you want to call in, 0116 482206. So Ibrahim was discussing some of the problems that unfortunately happen when it comes to buying a house, boundary disputes, not having planning for a conservatory, not being able to build in your back garden. And then he talked about gifts. A common problem with gifts, commonly parents, uncles, aunties helping children buy a house, but then being removed from the house. That now brings us on to another sadly common one, which is divorce. Divorce rates are sadly on the increase, and when you've got a situation where parents are helping children with property, where do they stand? For example, let's say a parent helps son and daughter-in-law or daughter and son-in-law with a deposit. They tell the lender that it was a gift. They sign everything to say it was a gift, but in fact, now that there's going to be a divorce, they say they want their money back because it was a loan. Where does that stand?
That's very, very dangerous, and that obviously gives rise to a civil claim. The parents that have got this expectation of getting the money back, they would have to start a civil claim or send a letter before action to see what monies that they can recover. At the end of the day, they've declared information to the lender, the parties buying the property, they've signed a statement of truth, and if anything's been done to mislead the lender, then obviously that goes against the mortgage conditions, and they could be in serious trouble. Where I don't specialize in matrimonial law, but from my experiences with my colleagues, when this situation arises, there are some instances where things can get resolved amicably without the need for litigation. And again, it's a case of laying all your cards on the table and having a discussion with the parties that are in the dispute. But it's a bit of a minefield, Rafique, and you doing litigation, you've come across this more than I have. And
so let's turn the tables now. You can ask me a few questions.
Yes. Yeah, I think the time's right, because I think there's 13 minutes left. So so when you are involved in this situation, Rafique, how do you advise parties?
So one of the points you made is a very valid one, that if the parents, typically it's parents, have signed to tell the lender that it is a gift, obviously they have told the lender that, so their son or daughter can get those monies from the lender, and they've told him it was a gift. Now if they try to switch the position, it's actually very worse than that, because it's in fact potentially criminal, because they effectively lied to the lender to get the money, and now when it suits them, they want to say it was a loan to get the money back. So actually it is really serious. I know one of the things that our firm does is it makes sure that they sign a document to make sure that it is a gift, so there's no grey area on them later saying that it was or it was not. But yes, sadly, if they signed a document, then it's near impossible to then switch their position. But talking about litigation, it's potentially a criminal matter. What are the types of litigation issues can arise in conveyancing that I can talk about?
It's so wide. There's a big overlap there. I think one of them could be is when, for example, when solicitors have not done their due diligence, and sadly, when you go and sell the property, you realize that your sale's stuck because your acting solicitor at the time of purchase has not carried out certain due diligence practices. Such as, for example, they've not sent you the searches. They've not sent you the local search, and on the local search, it clearly states, it flags a few issues up, like the property's it's in a conservation area. You've then subsequently built and you've breached that element of the local search, and now you're going to sell the property. The sale can't progress because the new buyers solicitors, they've advised their client that, look, don't proceed because you are in serious breach. Another one that we discussed was when we are acting for a buyer and the person gifting the money says, can you also act for me as well? That can prove hugely dangerous. Going back to the previous shows that we've done with commercial property, when you don't have a schedule of a condition and you are now vacating the commercial premises, you've come across various dilapidation claims.
Okay, so thanks for that, highlighting some of the problems that can arise. In terms of leasehold, I want to ask you about that. We've seen the price of freehold, sadly, is becoming quite ridiculous. And there's this term that's coming up called leasehold fairly regularly. Yes. And we had a query the other day where someone said that they've bought a property, but after 199 years, they've got to give it back. Now, they're not particularly bothered in terms of living there, but if they sell it, say after 50 years, then there's only 150 years left, but they thought they owned the property. What does that mean?
Well, it's a leasehold, so there's a freehold element and there's a leasehold element. The freehold is owned by somebody else. The leasehold element will never be yours. You may have a long lease, which in essence it is your property for a large period of time. But however, it doesn't have much value when you're not going to be owning it in 150 years time, or even, let's take a basic example of 80-year lease.
So is that as the same worth as what someone says is a freehold? Is it the same?
It depends how you look at it. You can't, as lawyers, we can't use those words. But if it's a long lease, it's fair to say that they've got the right to that property for a considerable period of time. But sadly, given we've got a shortage of housing, a shortage of land, a lot of flats, apartments are being built, and they're all being built with this proviso that they are going to be leasehold. So really, you as the client, customer, you've got a decision to make. On one hand, you're going to buy a property that's leasehold, but it won't be worth much as a freehold, depending on what part of the country it is. And eventually, as the clock runs down, that property then goes back to the freeholder. So
what do you think if someone's buying a property and is freehold still worth it? It seems as if you can buy a 2-bedroom house now, sadly, for about £180,000. Is it really worth it anymore?
It depends who's buying the property. So people that have got the funds, for them is no big issue. If you're a first-time buyer, it depends what you class as value. And but even with freehold properties now, Rafique, especially in the new development areas, there's an element of service charge. And
what does that mean?
And that service charge you have to pay to a management company that can maintain certain parks, gardens, certain features in the development. And one of the dangerous things that you've come across is when lawyers are not revealing what those service charges are to the buyers, to their clients, and what the service charges can increase to. So, for example, in some parts of the country, a service charge could be fixed for £100 for 10 years. After 10 years, it could hike up to maybe £1,000 a year. And that could put somebody off. And again, if you've not notified your client of that, and that affects a future sale and refinance, then there's potential negligence there.
Okay, thanks for that. So just to recap where we were, so this is the legal show with Rafique Patel and Ibrahim Kadri. We went through a number of matters in terms of conveyancing, sales and purchases of property, which is a very popular item at the moment. And I'll talk to you about auction properties in a minute.
Yes.
And just tell us a bit about how that works. But Ibrahim was talking about, sadly, if you don't carry out some detailed due diligence, and he explained how some conveyancing can be done for as little as £300 or £400 or £500. Some people will charge £1,500, but it depends how much due diligence you do. And we're talking about a significant sum of money you're spending now. He spoke about planning permission issues, building regulation issues, there being water apparatus in your back garden, boundary disputes, all sorts of problems that can happen. But I now want to talk to you about auctions. Some people see them as quite exciting. You're sitting at home, you're buying a property, you bid, and you might get lucky, and you might end up with a property at a really good price. And so that seems like everything's moving electronically now. But then we've heard some howler stories as well, how some of the things that you've mentioned happen. So how is it that you can buy a house but not even go to see it, or not read up on the documents or get legal advice? How does that work?
It's quite bizarre.
Ibrahim, I know you like to talk, and we've got 6 minutes as well.
I'll try to speed this up. Right, first things first, don't get too excited about auctions. Yes, they're good opportunities to buy properties, but like the theme of this show has been due diligence, right? So if you feel comfortable, the hammer struck and you bought the property, there's expectation that you've read.
What does a hammer struck mean?
The hammer struck, so you've done the deal, so you've exchanged at auction.
Right.
So when you physically used to go to an auction, you used to have an auctioneer who'd strike the hammer.
What if you haven't got the money? You just press the button.
You press the button, and then you are in dangerous territory there, because you've parted with those fees, and now you're working backwards to say, right, how am I going to get the money? Now, if you don't have the money, the auctioneer and the vendor and the solicitors will keep hold of a deposit.
Really?
Right? They can even sue you for breach of contract.
What does that mean?
So basically, the contract was entered into on the basis that you would buy the property.
I've got to interrupt you, Ibrahim. I know you don't like it, but we've got a text that's come in. It says anyone looking to buy a leasehold property must insist on a leasehold management pack, which the seller usually must pay for. Tell us about that.
Right, the leasehold management pack is a crucial document. It's got all sorts of information. It's got answers to all the things that we've discussed. So, for example, it'll talk about ground rent, service charge, Section 20 notices, which is a discussion for another day, and also if there's any future forecast if the service charge and ground rent prices are going to increase. Because if the prices are going to increase, that could deter or prevent a buyer buying that property.
Okay, just going back to the auctions, quite interesting stuff. You press the button, you buy the property. You now decide, oh my God, I shouldn't have done it, or I shouldn't have done it.
Yes.
I've gone on the internet and I've seen a whole load of properties which were less.
Yes.
I got excited. What happens next?
You need to get yourself out of that legal situation. Now, some auctioneers, if they found another buyer, they might be a bit forgiving. Those who are ruthless will insist, we're going to keep a deposit and we're going to pursue a litigation claim against you.
So do you have to pay the deposit at the time you bid?
Yes.
I
yes,
see.
Yes.
Okay, so they've now got your deposit. You've changed your mind. You've seen actually you've been ripped off because there's loads of properties which are lower. What do you do next?
Well, it's up to you. Do you persevere? Do you vary the contract, which will take a lot of effort, or do you approach a very good litigator who can pursue a claim on your behalf to get you out of it? However, chances are the bargaining powers, it's with the vendor and the auctioneer. So the key message here is do your due diligence before you bid, review the legal pack online, go and physically inspect the property as well. Those people who are brave and who do it without seeing the property, that's all fair and good, but when things go wrong, you can get embroiled in a legal battle.
Isn't it exciting though? You can end up with a property significantly less than you would have paid if it had gone on normal estate agents' boards.
Some things are too good to be true. The reason why people sell properties at auction is because they are distressed, they're facing repossession, or it's for a commercial reason whereby they need funds so they can go and move on to another project. People don't sell properties at auction because for the fun of it. If that was the case, they would have sold it through normal means. It may well be that the property's been on the market with an estate agent for 9 months, it's not been sold, and all of a sudden they're now in that distressed situation where they get an auctioneer to sell it, and therefore they've passed the burden on to you.
Okay, last quick one, Ibrahim, and you've literally got 2 minutes, is that you buy a property at the auction. It's described as 4 beds. It's got 1 property in the attic, but when you buy it, there's a problem with the license. So the local authority have now come along and said, I'm sorry, the property in the attic, the room in the attic, you've got to close it. It's 3 beds. What do you do?
If you've bid for it, you've got a right to inquire about this, and the chances are that the vendor's misled you. The vendor's got a duty when they're filling out those forms, they've got a duty to disclose to the best of their ability and knowledge. If they've misled you, then you can potentially get the contract rescinded and just walk away. Obviously, it's a different area of law, it's a different element, it's a different legal battle that you're facing, but if there's been if you knowingly misled somebody, then you are going to face a battle.
Okay. All right, while we've got just a minute to go, I'm just going to count down some of the things that we raised. So it's the legal show with Ibrahim Kadri, Rafique Patel. We went through house sales and purchases, which are very common at the moment. And we talked about a number of issues. Ibrahim spoke about problems that you can have with your property if you don't have any planning permission for, say, a conservatory. He spoke about the issue of gifts from parents, and sadly, if a divorce happens, he spoke about you could have water apparatus in your back garden and not build over. He spoke about a number of different issues. He spoke about why financial due diligence is necessary and why lawyers ask for where the money has come from. So thank you very much. I hope you're having a good Ramadan, and we'll be back next week. It's Rafique Patel and Ibrahim Kadri from Bond Adams Solicitors. Thank you very much, Ibrahim. Just last words over 10 seconds.
Thank you. Enjoy your blessed month of Ramadan, and Ramadan Mubarak to everyone.
Walaikum Assalam.